So good morning, everybody, and welcome back to the second day. I'm really excited about this panel. We're talking about emerging markets and kind of the opportunities that we have, not just in the US, but abroad, and kind of the layering of risk and opportunity, and perhaps also access to justice. So I'm excited to hear this panel. Thank you all again. Breakfast in the back as always, and I appreciate you coming out this early. Once the students wake up, they'll be joining us as well. Thank you again.
It is 10:30. So I'm Tim Scran. I'm merely a server here. I'm dressed in black because I'm only the moderator. But we've got a distinguished panel. Doris Torres, going to the middle and not going necessarily down the line. Lawyer from Peru. I'm sorry, I didn't see that initially. Extensive experience in investing in so-called emerging markets, both litigation and arbitration. Has deployed, significant amounts of money there and in the U.S. as well. Immediately to my right, my left, Robin Davis. She's the senior investment officer with Woodsford, based in Philly. Also a lawyer, background in technology, patent law, MIT graduate, I think, so she's back in town. But now is looking at investments for Woodsford, and is going to talk about particularly their focus on emerging markets. And then last but not least, Ian Cunningham, here from Ireland, CEO and founder of Affinity Finance, which has a very interesting process of investing in, I think, principally personal injury claims, but also commercial claims, and a little more probably math-based than some of the other folks that we've heard from. And they're going to tell you a little bit about what they do and their focus on emerging markets as we go along. Okay. We've got a relatively small audience today, so I don't think anybody would mind if a person raises their hand and wants to ask a question. We can be a little more conversational here. Okay. When I first saw this topic, I thought, okay, emerging markets. What is that? You've got to emerge from something to something. I thought I'd give you the sweep of history in about maybe 30 seconds, something like that. Emerging markets for litigation finance specifically. So where did all this get started? Well, there's a gentleman in the back of the room getting coffee right now who could tell you all about what happened in the 13th century. A chap named Edward Longshanks decided he didn't like investments in litigation back then, and so he passed a law that became champerty in our modern common law system. Took a number of years to come around to what we did in the United States, and that is lawyers essentially disregarded the notion of champerty. Please go examine why the U.S. judicial system permitted lawyers to engage in champerty through contingent fees. It's not a clear, there's not a clear answer to it. But contingent fees came along, and that was the first really robust introduction in the modern world of investing in litigation, back into our system. The Australians got interested in this phenomenon. Remember, Commonwealth, common law country, loser pays system, no contingent fees, no access to justice. New South Wales, 15 years ago, passed a statute to effectively abolish champerty in most kinds of situations. And so what we know as modern third-party litigation finance was born, I think it's safe to say, in Australia. The English, faced with their own problems with access to justice, no contingent fees, the so-called green card scheme where lawyers were paid by the government to represent the impecunious in claims. In other words, yes, the government was financing litigation. Didn't like it, and so they decided to introduce third-party funding, so to speak, in about 2007. So that sort of institutionalized, regularized the notion. And the Americans looked at that and said, well, we've got contingent fees, we're investing in litigation, what do we need outside capital for? So that was the sort of earliest development. Did all of these phenomena spread immediately into the Commonwealth? No. I can tell you when I launched Juridica in 2007, this was actually, I guess, in 2006, I planned to put Juridica, I initially incorporated it in Bermuda because I wanted to go to Bermuda as well. And we got on the phone with our underwriters and counsel. I won't name the large Bermuda law firm, but they said, no, what you're proposing to do would be illegal in Bermuda, even though it had just been legalized in England. And so you ought not to base Juridica in Bermuda. And I said, well, I've got a great idea, and that is let's go to Guernsey, because Guernsey, also a part of the UK, doesn't have old notions of champerty because they were Norman French, and champerty, even though it's a sort of a French word, is really a part of the common law not known in Guernsey. So there goes Juridica to Guernsey. Burford came along afterwards to Guernsey, and a number of others. Woodsford may even be in Guernsey. I can't remember.
England and Wales today.
Okay, but what I'm trying to say is that, when you look at emerging markets, I would submit that the Commonwealth is still very much emerging into this area. There are changes going on in places like Cayman and so forth that are very interesting. But I think what we want to focus on today is more civil law systems, perhaps, but happy to talk as well about Commonwealth and common law. So with that, I thought we would just kind of run down the line here and have each of our panelists say a few words about their experience in emerging markets or what they do when they do their jobs.
Sure, thank you. So I'm Robin Davis, a Senior Investment Officer with Woodsford. And at Woodsford, we look at investing in cases around the world, as do most of the funders, and we find of particular interest emerging markets because there's opportunities there that haven't been tapped yet, and we are always looking for new places to expand, new ideas, new ways to be creative, and obviously to improve access to justice. I agree, obviously, that civil law countries are frequently more amenable to integration of litigation funding than common law countries just because of the history of champerty and maintenance. But you do begin to see changes, for instance, in areas like Hong Kong, Singapore, and the Caymans, where there have been recent changes, funding beginning to come in typically in areas such as liquidation or bankruptcy proceedings, and also for international arbitration. I think both Singapore and Hong Kong are very excited to make and grow their presence as seats for international arbitration, and in order to do that, they recognized that they needed to be open and amenable to litigation funding, which is extremely common in investor state arbitration and in commercial arbitration and arbitration of all sorts. So my particular area that I was hoping to talk a bit about today is one of the emerging markets that we at Woodsford have been spending a lot of time on, and myself in particular, I have a technology and IP background, and we have really been overwhelmed by the number of opportunities both in IP and elsewhere coming out of Israel. Israel is kind of known as a nation of startups, if you will. So there are 1 million tiny technology companies starting there probably every day, and many of them actually do quite well and have become large successes. But as is probably similar to the experience in Silicon Valley, a huge number go somewhere for a little while, but then ultimately peter out. We have seen that this kind of cycle of startups runs into many of the same problems that you see coming out of Silicon Valley. These startups are partnering with larger global behemoth companies at initial stages, and then sometimes transactions go wrong. Technology appears to get incorporated without partnership with the smaller startup company, and these companies can find themselves in dire straits or even frankly just standing there holding nothing but their patents. And we are able we have had great success and really a very warm reception in Israel, talking to various different companies about how we can assist them with funding their claims. I think what's interesting about Israel, even though the country itself is very open to litigation funding, and we are obviously opening to funding appropriate matters in Israeli courts, is that many of the opportunities we're seeing are claims that would be best brought in another jurisdiction. Sometimes patent claims suitable for the US or Europe, or contract or other matters similarly destined to be brought in the home of the counterparty or the infringer or whatever it may be. So I think it's been an interesting observation to us as we explore these emerging markets. We're actually finding many folks with potentially terrific claims that are deserving of funding, but not in the market they came from. And so that's been an exciting development, and especially with much of the opportunities we've been seeing out of Israel, you know, the company, the claim holder, the patent owner may have an Israeli lawyer that they are working with who has advised them, you know, you really need to bring this case in England. You need to bring this case in the US. And so they need a connection also and a recommendation to a lawyer in the proper jurisdiction who could handle their claim. Because Woodsford has a presence in Israel, we actually just opened our office in Tel Aviv about less than 2 weeks ago, actually. But we've had a presence in Israel for a while, and we are, you know, happy to kind of make some introductions between these claim holders who come to us with their Israeli lawyers and a great claim, to lawyers in the right jurisdiction where they should actually be suing, and make sure that, you know, we have the right counsel involved, which is, I think, in contrast to many of the jurisdictions where funding's been going on for quite a long time. Typically, the way I think most funders see a claim or a case arriving with them is with a lawyer and a law firm already attached. So these are some exciting and different opportunities where we've been able to partner really from the ground level with finding new claims and new opportunities for Woodsford to invest, and also to help folks who've gone through, you know, terrible wrongs find some right, perhaps not in their own local courts. You know, we're also seeing some domestic funders active in Israel too, because you know, once funding starts taking off, everybody sees what a good idea it is. And some of the global funders, in addition to Woodsford, are getting into the game in Israel. But it's still, you know, nascent market arising, and we are seeing a ton of interest. It's been very exciting, and we look forward to having lots of claims to fund both in Israel and around the world with Israeli claim holders.
Great.
Thanks.
Got a lot of questions, but I'll hold on to them. So, Narkis, please.
Yeah, sure. Well, first, thank you for the invitation. Glad to be here to share some insights and information regarding what is happening in emerging markets, and in particular in the Ibero-American market. I mean, Latin America, Spain, Portugal, which is our area or work or expertise. I have some numbers to share with you, because I think a numbers talk better than 100 words, that will show which is important. Not a particular development in a year, but a trend. I have put together, you know, the last 5 years, both in commercial arbitration and investment arbitration, to show you what is happening in Latin America, Spain, and Portugal. The first number that I want to share with you is regarding the number of cases that are carried in the International Chamber of Commerce, ICC, one of the largest and more respected arbitration centers in the world, regarding the cases that came from Ibero-America. In the last 5 years, it has gone from 759 to 810. That's a huge number. Mostly more than half of the cases that come from emerging markets come from Latin America. And if you apply the typical regular number that as an average 5% of such cases should request or have financing by third-party funders, you may have like around 40 cases at least should be funded. The other number is regarding how big could be a market. You know, just a very interesting example. As you know, UK has a really large number of cases, arbitration cases. But last year, for the first time, Brazil has the same number of cases than UK, 51 cases at the ICC. That's huge. No, considering the tradition of UK, the importance of UK, or the economy of UK. Maybe now, after Brexit, or what happens there is going to be lower even than Brazil or emerging markets. The third other number that I want to share with you is regarding what is happening regarding the global trend. I mean, how global could be this particular market? And it's very interesting because of such number of cases that I mentioned to you regarding the last year, 810, you know, 371, which is a little bit less than half, came from 2 Latin American parties. And 435 is one other global party doing business in Latin America. Could be a US company, you know, that has a dispute with a Chilean company, or a French company doing business, both companies in Brazil, in Peru, in Colombia. So you have nearly half and half of disputes from global corporations and from local corporations, which shows the strength of the market. You know. Now, money, the claim amount which is involved in such disputes, you know, around 260 cases, which is around 30% of the last number that I mentioned to you, the 810, are disputes between $500,000 and $5 million. But, you know, 30%, which is around 243 cases, are between $5 million and $50 million, which certainly, you know, are an interesting market for any funder. You know. This could show you what is happening in the commercial side of the business. Now let's take a look at the investment side, the investment arbitration side. You know, in the last 5 years also, has been around between 10 and 20 cases related to LATAM that are settled or carry on in the International Center of Settlement of Disputes, ICSID, which carries the World Bank Organization, which carries the most important center to carry disputes between investors and states or state-related companies. The other number is regarding the claim amount. Usually all the aggregate claim amount is disputes between $20 billion and $30 billion. The cost, which is obviously the target of any funder, is as an average and not less than $5 million per dispute. Could be 10, could be 15, depending on the complexity of the case. But the majority of the cases that are related to LATAM are energy disputes, infrastructure disputes, you know, and even, you know, shareholders disputes. You know. And finally, of all the cases that are carried in the ICSID Center, 30% are related to LATAM. So this is what I first want to show you around, you know, the market, the size, the trend, the growing perspective of LATAM and Spain and Portugal as an emerging market for third-party funding.
Right. Ian, please.
Yeah, thank you very much. And again, Ian Cunningham is my name from Affinity Finance, London-based funder. Like Fiona, Narcus and Tim have said, emerging markets is something that's very interesting to ourselves, something that we believe is important for all of us to continue to monitor and have a look at. We in Affinity Finance have a different model, as Tim mentioned. We have 2 divisions. One is a consumer lending model, which is basically small claimants. And it was interesting for me yesterday saying about and talking about claims under 100,000. Our minimum claim quantum value on those is 40,000 sterling. So we run claims, high volumes of deployment between 12 and 15,000 across thousands of claims on a monthly basis. And that's on a consumer FCA regulated basis. We also do the commercial side of the business, which is the second division, which looks at class actions and the normal business lending type of commercial claims. I suppose emerging markets is very, very interesting to me because I'm from Ireland, so when I went to the UK, that was an emerging market at the time, and so was everything else. And I suppose scale is what's so important about emerging markets for most of us. We're all looking to deploy capital into good claims, whatever jurisdiction is. I think it's very interesting because I suppose we look at Brazil, which Narcos has mentioned, and we see some claims which we have assisted in being brought in the Liverpool courts in the UK. So big claims from Brazil being brought into other jurisdictions. And I think that's very, very interesting. And that's because mostly people believe the Brazilian courts are laboured and are too busy. So it could take you 10 to 15 years. This is something that, again, is my intel on this, and I'm open for correction. We also like Spain. Spain is a country whereby there is a lot of smaller type lawyers, small law firms, could be 5, 6, 7 in a practice partners, very interested in funding, like the consumer type model. You don't need a license, unlike you do in the UK and Ireland. It's something that I have worked with and co-funded with some of my funding partners, as in some of the litigation funders, and we've looked at these markets very successfully and have started to work successfully on claims. I think Spain is a very interesting one because, again, there is huge scale. There's precedent set across certain case studies, which is our model, where we look at a claim which has already been won. We set a criteria and a precedent, and then we roll it out to our preferred partner law firms. I think when you talk about emerging markets, you also have to think about, it's not just the market, it's the scalability, and it's also how many claimants can we assist and help that cannot otherwise run these claims. I believe for us in Affinity, probably the greatest emerging market is America, is the US, because obviously this is highly, it's a highly competitive, but yet there's a huge opportunities here. And to this day, I suppose, speaking to a lot of people, and this has been a brilliant experience for us, most lawyers here, I think it was 15 or 20% maybe use it, so there's 80% opportunity out there. So for me, looking at the US would be very interesting, something we're definitely working on at the moment. Israel, again, I think more class action, group actions were taken in Israel than any other country in the world, which is something that maybe we haven't really looked at, and it's interesting that Robin has got an office there now, and I think they will be very successful. There's already, I suppose, we talk about emerging markets. The Romans were doing litigation funding. There was rich Romans who helped poor Romans to fund litigation. So this is not a new product by any means. This product has been out for years and years. It's only now that the financial hedge funds and the various bodies who have capital to deploy have looked at it as a very uncorrelated market and are very interested in it, which means it's becoming more like a financial derivative. And as I said, most of us are financial businesses now which happen to invest in claims. But we are being run like a bank. We're certainly being run very much like a banking system. We're regulated. I started out in Ireland. We went on a regulated basis, even though we did consumer lending, which I know in the US is look at an investment in a claim rather than a loan to a claimant. So I'll say to you, I think that probably for us, and I think for all of us in the industry, there is so much opportunity in each of our jurisdictions. Even in the UK, we have been based there since 2014, and when you talk about numbers, just to share some on what we do mortgage mis-selling, we could have some of our originators, which I think is another thing all of us as funders have to look at. How do we originate our claims? How do we bring them in? How do we obtain our business? Because mostly we're going to law firms and depending on others to bring us business. So I think we would have, this morning I got a call, so a guy would have 500, 600, 700 claims a month for us, and some of our claimants and some of our CMCs would have 20,000 claims, a pool of 20,000 claims. It's unbelievable the numbers that are in this sector. So I think South Africa as well, I think Holland. I think we should all look at courts where they are robust courts. Holland is now opening up as a centre of excellence for a lot of the actions. We work on the trucking cartel claim in the UK and also Spain. And it's a similar action depending on the jurisdiction, but very, very similar model. So I think, it's a very interesting time, and I believe that the world is probably an emerging market at this point. And I think we couldn't be at more of a crest. We're on the what we say, I suppose, we're on the crest of a wave at the moment in regard to this product, and everybody in this room is very, very lucky to be involved. And it's a hugely exciting time for all of us, I believe.
Yeah. Well, at the risk of stating the obvious, the title of this panel and a lot of what you've just heard refers to markets. And if you're interested in policy, the notion of access to justice, hang around, you're going to have a good panel at noon. But that's not what we are talking about. Thank you very much. We're talking about markets. That is, where do you go acquire claims? What are the claim-rich environments? How do you identify claim-rich environments where you can deploy money? And if that triggers a thought that, yes, this is a very opportunity-driven business, you're exactly right. I was intrigued. I'm going to step out on a limb here and say, maybe to Beth, when you focus on Israel as a claim-rich environment, if you will, particularly for intellectual property or business tie-up disputes, you're not intending to litigate there. In fact, I might ask, do you take any cases where you actually, where the litigation is actually brought in Israeli courts? Or?
So I think we're open to that for the right claim.
Mm-hmm.
I think for a lot of what taking a U.S. perspective from maybe to ground our audience, a lot of the traditional really forerunners and areas where you get a lot of litigation funding has been international arbitration and also patent and IP litigation. Well, what do those have in common? These are types of litigation or arbitration that involve really high costs. Forget about even if your lawyers are willing to put their fees 100% at risk. There's typically a huge amount of expert fees or costs associated with depositions and court fees or arbitrators' fees that make these very expensive litigations in the first instance. And so that's, it's a combination between high costs and high damages that kind of opens the door for funding to be a great solution for those particular folks. In Israel, sometimes because it is inherently a smaller market, it's a much smaller country, certain types of claims, like a patent infringement claim, may not be able to yield that same potential damages exposure, even if it's a very strong claim and just as strong a case on the merits. And so that's why, assuming there would be a counterpart patent in another country, that might be the more appropriate jurisdiction. So I think to date, we have not yet invested in an Israeli litigation that would be brought in the Israeli courts. I think we are excited and happy to find the right case when that comes along, and we are, open to looking at them and are looking at them. But so far, it's been mostly opportunities arising out of Israel that we fund in other jurisdictions.
And Israel, if I remember my comparative law, is principally a common law style jurisdiction. It's a blend.
Yeah,
but it's got a lot of common law elements.
It's unique, but it's actually, I'm not going to be able to remember the name of the case because my Hebrew is non-existent, but there was a case in the Nazareth District Court actually recently, I think in 2017, so only 2 years ago, where the court not only found the use of litigation funding to be acceptable, but basically said, why don't we see more of this? It's a very friendly, welcoming regime to funding in their own courts. Mm-hmm. It's just a matter of finding the right opportunities for investment from the funder perspective.
Right. And I'll say, when funders are looking at cases, I mean, they are self-limiting in a way because they shouldn't be investing outside of their internal expertise unless they are relying totally on outside advisors, which very few funders do these days. In other words, they want to be able to look at a case at a threshold level and say, I get it, I think I know what's going to happen, I like this case, and that requires understanding what the jurisdiction is going to probably do with the case. So stepping outside of your comfort zone into a case that's governed by Nigerian law or what have you is going to place limitations on what funders are willing to do. I'm wondering about the civil law system. Now, I know you've done a lot of investments in and out of common law regimes, whether it's arbitration or U.S. courts or whatever, but is there anything about the civil law systems of South America that makes that a good place to bring claims, or makes claims there good or easier or more predictable? Or
Sure. I guess there are important pointers to mention regarding your question. The first one is, obviously, any legal system is the sum of individuals, that has a kind of mindset and formation. Latin America is a giant part of the world. We have like around 800 million people, and it will continue being more people rather than in Europe or any other areas of the world. Mm-hmm. So this population, when you go to the legal system, instead, here in United States or UK, 80% of the cases of commercial cases, disputes, goes to litigation rather than to arbitration. In Latin America, it's the contrary. 20% goes to litigation, 80% goes to arbitration.
Even domestic cases?
Yeah, even domestic cases. And domestic cases is very interesting because we are aware that we have limitations regarding our institutional side of the market. We have to make a lot of work more in courts. So for that reason, for a matter of survival, people go to arbitration, where you can be able to pick the right lawyers, the right arbitrators to try your case. So you have like a more friendly environment for arbitration rather than to litigation. Mm-hmm. And in that sense also, as a matter of regulation, we don't have anything related to chamber trio maintenance. On the contrary, it's very friendly to litigation funding. Yeah. We did a poll like a couple of years ago, and we revealed that the last topic of importance, of worriness of the lawyers are litigation funding. They are more interested in, making able to the people to know how many challenges has arbitrator has, how many cases has it tried, to more openness of the arbitration centers. But litigation funding is something that is looked after rather than prohibited. The other issue is human capital. There are many great practitioners. Many people from Latin America came to United States or to UK or other European countries to get master's degree or learn about common law systems, and they try to apply the best of both worlds. You are not going to find the craziness of discovery in arbitration, for example, and the costs that carry that. So arbitration is a mixture of regulation that is very practical and more friendly, And obviously, regarding the size of the cases, is in a growing number, We are talking now of multi-billion disputes. Maybe in the third round, I can share some examples of disputes. So yes, I see that the key word is sustainability, We will see a sustainability environment for arbitration and litigation funding, And regarding regulation, besides this issue of that we don't have any limitations or discussions from the past, like the chamber tree or maintenance or usury laws, there is also a benefit to go to arbitration rather than to litigation. Let me give you one example. In Brazil, one of the largest markets, there is this regulation that obviously was created by lawyers and the lobby of the lawyers that established that if you go to a court system, if you get any amount of money, any compensation, you have to pay 20% of such compensation to the lawyers, mandatorily. That crazes the system because it could be like a break-even point for any funding agreement. So for that reason, many people prefer to go to arbitration, where that rule not apply, because it has to be a consensus. If the parties agree to apply such a rule, applies. If not, not. So even for economic reasons, people prefer to go to arbitration rather than to litigation.
Well, let me then slice this notion of markets horizontally rather than vertically. Or in terms of practice rather than geography. Ian, do you like intrinsically litigation claims or arbitration claims? Can you answer that?
Well, we would be definitely litigation claims.
You like litigation better.
I suppose one of the reasons is because of I suppose in our model, the precedent as preset through the rules of the courts allows us to upscale on a type of claim that we already know has won. So when we set the criteria, once we work within a certain bandwidth, there is no reason for the lawyers to lose the case. Now, we all know that's not the way the world works, unfortunately. So therefore, we tell them you shouldn't lose the case, but that is not, but at least we're narrowing our margin and we're hoping that we have a 90% chance. We're hoping to obtain rear enders in the personal injury market, in the financial missell and other areas we work in. Fixed costs, I think, Tim, has come into the UK, which has changed the model as well. So there's lots of fixed costs across different sectors, which is impinging on the growth of law firms. And that's why when they brought in the alternative business structure, bringing business people, so I can buy a law firm, a non-lawyer now can own law firms and run them. And those non-lawyers are very commercially minded, and they are the ones who are driving the market, believe it or not, to this day. So they are coming to us from a position of we need capital to grow our business. We have one law firm which has gone from 40 to 160 people in a year through our capital and through running successful claims. So I suppose the message to lawyers should be, use the industry's capital to build your business.
Yeah. Let me tidy that up slightly, if I may. In England, in 2007, when the Parliament permitted third-party funding by statute, they also permitted something called alternative business structures, ABS, which allows outside capital investments directly in law firms. So this regime change permitted investment in claims, but also permitted investments in law firms. And for those of you who didn't know that, and you're wondering, how is Wall Street going to compete with the Magic Circle firms or the high street firms in the UK, you have to consider the impact of direct investment into law firms, which you've done a lot of. I mean, you're doing more of, I take it?
Yeah, and we don't lend to law firms. We lend to the claimant. So we lend to the claimant, so it's an off-balance sheet loan to the claimant, which goes into the law firm directly to pay for their disbursements. Now, just on that model, they're all working on a contingency basis, so there's no fees paid. So the law firm is on the hook for trying to win the case, which keeps them in some way right and correct and keeps things moving. But of course, we have also got the after-event insurance in the UK, which is another very important part of our product, which means that the insurance company pay you back the disbursements if you lose the case. So it's head you win and tails you don't lose. And that is very unusual in the US, whereby your third-party risk, I suppose, is dependent on how strong your insurance company is.
Right. Well, to a hammer, all the world's a nail. In America, we have the so-called American rule, and in England and the Commonwealth, they have the so-called English rule of loser pays. So we don't really care about after the event or ATE insurance in the United States so much, because you can sue anybody for anything here as long as it's done within the rules of professional ethics and stays outside of rules of frivolous claims, and you don't have any consequence to that. But that's an impediment, so that that is a factor you have to consider in investing in any Commonwealth system outside the U.S. is that you've got to pay if you lose, and so insurance has come into those markets to solve for that at some rate of usefulness. Its usefulness has been doubted by some, and
it has, because obviously, like all good insurers, they don't come in until afterwards. So they don't come in until they know the risk is very small. So they let you run away on your own, and then you find out, oh, that's a great risk, we'll now help you out. So it's becoming it's starting very, very strong in Australia, which obviously is the home of litigation funding in many ways. But insurance is starting to move into that market, and insurers are starting to move, AmTrust and other A-rated insurers. And I think it is coming small. You don't need it here, obviously, but it would be nice to know if you lost your claim or lost your case that you could recover some of your costs, even if you're a normal claimant. Doing
That's
your own thing.
self-insurance. That's insuring your own
Your own.
risk of investment rather than the risk of having to pay the other side.
Exactly.
Right. Yeah.
Exactly.
Yeah. I mean, clearly that's a growing market. Well, Beth, what do you think? Arbitration or litigation? If you just had, if everything else was equal, which would you rather have? Pardon?
It's relevant.
Oh, I'm sorry.
It's okay. So you were saying arbitration or litigation, not knowing anything else? Well, I guess if it's an emerging market and I don't know anything about the courts in that particular country, then arbitration, I think, offers all of the kind of benefits of selecting your lawyers and selecting your decision-making, your arbitrators that Nargis was mentioning earlier. And so in that regards, it gives you, a certain level of comfort. However, I think that, generally speaking, I think litigation is a great place to go. So I don't think it's an easy call. It's just in the absence of other information to
All right. In terms of your underwriting, this is a senior investment officer. Okay. In terms of your underwriting and trying to figure out what's going to happen in a case, particularly out of a jurisdiction like Israel, right? Presume it's going to play out in some better known law, either English or American or something. But I mean, is there anything about one style of dispute resolution that makes a case a safer investment, a better investment? Or?
Sure. I think, obviously particularities of individual cases, but I think to call back, what you were just discussing with Ian, whether there's a loser pays regime, it makes a big difference to a funder, especially because, if a funder is going to be taking on some of that risk or writing an ATE policy or being involved in any such way, which does happen in some investments in jurisdictions that have a loser pays regime, that obviously changes the math, frankly.
Yeah.
Here in the U.S., I think a lot of U.S. lawyers don't even really necessarily think that way because we're trained not to in litigation because that's just simply not our practice. But it really changes the dynamics of what kinds of cases get brought, and I think makes litigation funding even more important in those jurisdictions from an access to justice perspective, because some folks might be able to find a lawyer to take their case on contingency but have no ability to handle any kind of after the event cost that might arise if they wind up being unsuccessful. So I think, we do, of course, always take into account different jurisdictions. And, speaking a little bit back towards my area of comfort where I practice personally in patent and IP litigation, there's a lot of folks and a lot of very sophisticated startups who get good advice as they are developing their technology will file for patents around the world. And they wind up having a lot of different options on which jurisdictions should they bring a infringement claim in if they're ultimately then later down the line facing a global infringement problem with regards to their technology. And it becomes an important factor, right? There's the German courts are notoriously quick and efficient with getting to decisions on both infringement and validity, and they have a high risk of injunction, which can, if there's a finding of infringement, which can, really strike fear into the heart of a larger adversary, even if you're a very small plaintiff. Whereas in the U.S., traditionally, there are large damages awards, which a lot of people find very attractive. It takes a long time to get there. So speed is not the asset for the U.S. in any kind of federal litigation, but it depends on what the claim holder's looking for at the end of the day and what makes the most sense. But I think we very frequently see multi-jurisdictional strategies, especially in the IP area, and sometimes with multiple fronts kind of timed and staged. And we love to consider these sorts of strategies where there are different triggers that can basically be pulled at different points in the dispute to encourage the types of resolutions that would make the most sense and be best.
I might make an observation. I'd love to know if you agree. I mean, it's hard to really think about the global phenomenon of litigation funding as really a geographic phenomenon. It's really sort of like an amoeba reaching out for the good markets, for good types of claims that can be found, whether they are sourced and brought back or taken elsewhere, or often these effects are brought about by changes in law, the reduction in the potential to get an injunction in the U.S. makes the potential to get an injunction in German courts or Chinese courts, something I recently saw, all the more favorable, right? So I don't know that geographic boundaries are really driving this growth of this industry so much as looking for good claims that have certain characteristics. I mean, do you agree with that?
Yeah, and I guess bringing the example again of arbitration, I guess you have to worry about two risks mostly: decision risk and collection risk. In arbitration, obviously, one of the advantages is that you have the opportunity to choose the ones who are going to decide your case. But the other important advantage is regarding the collection risk, which is the New York Convention. The New York Convention is an international agreement, United States is part of that allows you to get an award and execute such award in any of those jurisdictions, in any of those 150 plus jurisdictions. And it's like a final decision of the Supreme Court of each country. And as an average, here in the United States, could take between 3 to 6 months to do that. So the collection risk is reduced immensely if you use that particular facility. That is not allowed to court cases. For court cases, you have to follow up a recognition procedure that could take 1 year, 2 years, even more. Mm-hmm. So that's a key advantage, especially for timing. And you know, timing for funders is important because IRR is based on that. So I would say, yes, it's important how you structure, and that's one of the reasons we prefer to do a contrarian trade and go to arbitration rather than to litigation.
I understand. No, let me say this as well. With arbitration, there's no appeal generally. I mean, in state investor arbitration in front of ICSID or whatever, you do have an annulment process, but generally you're faced with, as an underwriter, deciding whether you're going to win in the case and not whether you're going to win on appeal, right? And it becomes far more binary, the sort of underwriting you do, and that makes it more difficult, more sweaty palms, if you will. I'm interested, Ian, do you ever bet on appeals? You said you were buying judgments.
We haven't. Obviously in the UK you can purchase, what's as known here as an asset purchase. I think Gertrude Keller did that famous one in New York. But recently Manolete went on the UK stock market, and they basically buy asset purchase claims out of insolvency, and that's their product and that's their market. So we have looked at those type of claims. We haven't actually purchased one. Mm-hmm. It's actually quite competitive in the UK for that type of business now. Having said that, I think your point, Tim, with regard to going into emerging markets, and all of us have an investment committee where we want to support great claims in timely jurisdictions and timely courts. And I suppose the most important thing every one of us have to remember for all our businesses, we have got claimants, and the claimants are our clients and should be the first port of call. So they're the people we must look after no matter what, because mostly a lot of the time we talk about IRRs, we talk about our investors, we talk about our shareholders. As CEOs and as people, senior people in the companies, they are very important. But if we look after the claimant, whatever jurisdiction they're in, and look after them economically, make sure the cases are run on a very tight matrix, that they are getting value for money, this business will thrive in whatever market we decide to go into. We have a rule, and I think it was brought up yesterday, whereby claimants can have a very bad result, and you end up with issues and problems and arguments. And we have one where a claimant must return 51% no matter what claim we have, even on the smaller type. Right down whereby we work with the lawyers to make sure outer contingency that the client is looked after. So I think when we talk about emerging markets, it's right to talk about not only where we get the claims, how we run them and how we look after the claimants.
Yeah. Dirty word, how we run the claims. Sorry.
Right, dirty words.
You're going to hear
our law firms
different
run.
perspectives on control and so forth. One thing you've been hearing up here, this is not a panel on careers in litigation funding, but I can tell you from my personal perspective, it is a lot of fun to get involved, I should say to participate in the strategy, because there's a lot of strategy here. I mean, Robin,
No,
do you?
yeah, it's tons of strategy, and it's a lot of fun to work with some of, lots of the best lawyers who come to you with a million different ideas, and it's brainstorming. It's a lot of fun before the claim gets filed to, sit down and talk about what might make most sense, and, what are the risks, what are the rewards.
That's right.
Yeah.
You don't have to get your hands dirty with a claim either, so. Comment?
Yeah,
And then
sure.
I'm gonna go to questions.
Especially in arbitration, I guess one of the positive, outcomes or litigation funding in that particular industry is leveling the playing field. I mean, usually lawyers capture any industry that they are involved, especially litigation as a practice, And sometimes, such control was not good. They forget, they think that the claim is theirs rather than of the client, So we funders want to go over and, level the playing field, Take some of such control and try to equilibrate the interests, And that's good. And especially when you are dealing with cross-border disputes, for example. You mentioned the globalization area or impact of the East industry. One topic that we are nearly every day involved now is structuring cross-border claims, where you could do a local strategy based on arbitration and maybe executing something based in courts, or using the great system that you have, costly but great regarding, discovery, and use such discovery in local domestic courts in LATAM. And it's possible. There are specific, procedural regulations here in the United States that allows you to do that. Mm-hmm. You can go over here, do a great discovery, take such evidence, and bring such evidence to local courts, and you win your case.
Yes, agreed. All right, I didn't leave much time for audience questions, but why don't we go to them if we have any? Yes.
Thank you. I just had a question to follow up on your point about getting your hands dirty in the litigation and the control aspect, and how you reconcile that or manage that in light of the rules that govern lawyers and funders, about funders not being allowed to direct the course of the litigation, that it's still a decision that's supposed to be managed between the client and the lawyer.
Right.
And I should say I teach professional responsibility, so.
So this is a trick question. Well, I heard Robin say decidedly before the claim is filed, and so I'll tee that up for you.
Yeah, I mean, I think that at least in my experience, we see most opportunities come to us before a claim has been filed. So what's under consideration is when a lawyer and or a claim holder brings something, it's like, do you guys want to invest in this? Here's some other ideas we've had about how we might bring this case. Would you be interested, do you think that, this would be a better investment or that would be? Sometimes when an opportunity comes to a funder, there are options on the table, and they are, we look at the different options and we provide feedback, and it is basically brainstorming. Of course, as is required in the U.S. and in many other jurisdictions, once the case is actually filed and we're going forward with an investment, we are a passive investor. We get updates, status updates, but we don't control or direct the litigation. But we typically have very good relationships with the claim holders and the lawyers that we work with, such that they are happy to give us updates and let us know everything that's going on. We don't tell them what to do, but especially because the diligence process of getting a claim from just an idea to actual funding involves a lot of, we really kick the tires hard on these opportunities. And sometimes in the case of asking our questions, I can speak to my own day-to-day work, I'll ask a question where the lawyer says, actually, how about this, that, the other thing? And it gives them some great ideas.
Yeah.
We are not telling them what to do. We are making sure our investment is sound, and in that process, it winds up with an even better legal strategy as the result.
I'm going to skip down to Ian, where in the UK, control is believed to be essentially anathema. Is that
Yeah,
fair?
no, correct. Listen, we never look to control. We have no interest in sitting with a lawyer controlling a case at any time. It's not where we want to be. So I think in a lot of the cases it is managing the plaintiff's expectation and your own. So we would meet a lot of times the plaintiff on the bigger claims, find out their expectations and try and manage that before we go into the negotiation fully. So if we felt, which we did recently on a 40 million claim, that we felt it was probably going to come in around 12, 14, and when the plaintiff, understood that and we felt that they were happy and would settle, then we could move forward. We don't want to get into a position, because we can't control maintenance champerty, and it's still an issue. Champerty is still an issue in the UK, and you cannot control, as you know. So I think it's managing people's expectations and your own expectation on how a claim might finalise. But that's on metrics as well. So you can't put in 500,000 on a £2 million claim on a 4X, because nobody wins.
Yeah. So this amoeba I was describing that's going toward the claim opportunities, maybe it's going toward jurisdictions where control is perfectly permissible. Maybe it's going toward types of claims where control is perfectly permissible. Because anybody who invested anything would know that if you have control over the investment, you're more likely to at least see the outcome quicker, make decisions that could be interventional or what have you. Another question? Is there insurance where the funder takes on the duty of controlling the litigation? There is, but does anybody have it?
Insurance.
Insurance over risk of control of your activities as an advisor in the courts. If you're going to take that in a jurisdiction that allows that, if in a jurisdiction where you're going to allow it, and as funder you want to have control and you have the experience of doing it, something goes wrong for the client, just like a lawyer, you can be sued for malpractice. So has anybody thought about getting that kind of coverage?
No, you do. You need that coverage.
Do you have that kind of
We
coverage?
have that coverage. Yeah.
Okay. All right.
Yeah.
And what do you?
But we don't control. We still don't control. But if somebody felt you did do something wrong, who knows? You're dealing with litigation. You need to be protected.
So if you affirmatively took on obligations for a plaintiff that wanted to hire you and give you half the deal, you would then you'd have to expand that into presumably that kind of insurance.
Well, I suppose we are in a different position than maybe some funders, where our shareholders, common shareholders, are insurers. So we probably look at things from a different point of view. And I come from an insurance background, so I'm always looking to share the risk, mitigate a risk, and offset it if I can. So maybe we act differently and think differently than some funders. But we would be very much, we don't control. So just so we can't have an insurance that says you can take over the case, and if you can't, you pay out, if that's what you mean. It's only if a claimant wanted to or decided to sue you, but for whatever reason. Well, the money it was put in, and notwithstanding the agreements to say no control of funders get nervous and they'll want to take control, and I don't have this kind of experience to know what happens. We just don't take control. Yeah, okay. Doesn't happen. Yeah. Can't happen. Well, and I'll leave it at this. Insurance hasn't kept up with these markets. Insurance doesn't really understand the difference between a lawyer acting not in his legal professional capacity and investing in a claim, and a lawyer who's giving legal advice. So even placing policies of this type are very, very difficult. I mean, I could give you statistics on it. But suffice it to say, it's difficult to find the kind of insurance that you're talking about, and so there's potentially a lot of gap in potential liability out there. One. Yes, that would be a good industry, and it doesn't exist. You won't get there. One last question.
Yep. Sorry, I have a question. Oh.
Let me grab this gentleman in the back, if you don't mind. Okay.
You talked about emerging markets in terms of jurisdictions. Have you seen something about industry sectors in general, like energy or?
I'm sorry, I missed the. Have we seen what?
have you seen a trend for emerging markets not looking at them in terms of jurisdictions, but about industries such as energy, oil and gas, or others?
I don't know. What do we think
Well-
about that? Emerging industries as opposed to geographic markets. Thoughts?
Well, the only thing I'm not quite sure, but we work in the financial mis-selling, so when we walk into Spain, if, for instance, if you look at an emerging market as in the Spanish jurisdiction, they would have huge amounts of financial mis-selling claims. So banks look like a major target, and probably always have been, and that's no harm. So that would be, but in other industries, no, I haven't really got.
Well, in our experience, there are like four, energy, construction, infrastructure, and corporate disputes, shareholder disputes. That's the most important areas of disputes of growth.
Yeah, I don't know if slicing it by industry necessarily fits. I mean, those are common industries. Also, we see a lot of technology litigation, but I think the industries that are most active in those areas are those that are most active in technology litigation generally. Litigation funding isn't showing anything different than probably the overall trends.
Okay, I think we have to close this up. Yes or no?
We can take one more.
We'll take one more question from this gentleman in the front row.
From Mr. Torres, you quoted or cited a lot of statistics about how many cases were brought and how many were funded and so on. That area that you have documented with detail has baffled me from the beginning. How do you possibly get the details in this impenetrable industry to say that so many cases, for example, have been brought in arbitration, which are usually, except for ICSID, private. And usually in litigations, most of the cases settle. So how do you get your statistics?
Well, luckily, there has been a change in the rules, internal rules of the arbitration centers. They are more open now. If you go to the webpage of the ICC, for example, you get statistics. There are independent reports also for Kluwer, or other academic institutions like American University that provides each year statistics regarding such cases.
How do they get it?
You can go to the webpage, or
You can't get it from...
You can get that information.
You can guess at it.
If
You
you
can
request
guess
such
at it.
information, you get it.
You can guess at it. You can't document it. You can't empirically find that information. You can guess at it, you can simulate it, but you cannot get your hands on
I
it.
have a different opinion and experience.
Okay.
I'm miscued. We actually go to 11:45. So, any other questions? Yes?
Thank you. When you think about the U.S. as an emerging market, what do you see as the most significant barriers to deeper penetration into the U.S. market?
Most significant barriers to...
More penetration of litigation finance in the U.S.
Thoughts about this?
What are the most significant barriers to further penetration?
You talked about having, maybe 20% of attorneys had some experience with litigation finance. 80% have not. How do you get that 80%?
Okay, well, I'll take an initial crack. I'm sure everyone's got a view. I think there's, a lot of it is education and willingness to try something different. I think we heard this a little bit in the keynote yesterday, but lawyers are risk-averse people who get trained on how to identify risks and avoid them. So trying something new just seems risky. People need to get used to it and try something new, get comfortable with it, and then embark on it. I think, over the course of my 10 years practicing in patent law, I can tell you that when I first started in patent litigation, there were basically no funded cases, and the times that you would hear about someone using litigation funding, it was weird, right? That was the reaction of, at that time I was working at a large firm doing mostly defense work, so it sounded strange to us. But then fast forward, 5 years, by midway through, at that time I was working with Quinn Emanuel, who is innovative and a market leader of a firm, but they were excited to try to find new opportunities and new ways that they could take on cases that were attractive to them and not potentially otherwise fitting within their model. Fast forward to when I left practice within the last year, basically any time that someone would be bringing a case with a contingent fee component, and I was at a small patent boutique in New York, we would put our fees fully at risk, but as far as the costs, of course we were reaching out to a funder, right? So it takes time, it takes education, it takes seeing other people do it and how terrific the results are. I think that the patent litigation experience actually is helping a lot with some of the big, large law firms in the US. People are seeing, the patent litigators are saying, oh, hey guys, we should be doing funding, and it's spreading to other commercial litigators. And I think arbitrators have had the same impact, because those who do large international arbitrations and now more in commercial arbitration are finding it to be such a terrific tool. They tell their colleagues. I think it's just tricky, if you've had your lifetime of, having your bills paid by the hour, if it ain't broke, don't fix it. But I think mostly people are open to new ideas when they see a great opportunity.
Yeah. I think the desensitization that occurred with patents, that has occurred with international arbitration, particularly state investor style, has been very groundbreaking in the U.S. I mean, I left, when I was talking about the history of this, I left out the fact that when New South Wales passed this innovative law saying Champerty doesn't prohibit investments in litigation, there was already a U.S. publicly traded company called Altitude that was investing in patent claims. Okay, so and that goes back to doctrines like the supremacy, not supremacy. Help me, patents. In the Constitution. Patents are exclusively a matter of federal law, and so state Champerty meant nothing to federal court litigation over patents.
Federal question jurisdiction, maybe?
No, it's another one. It's the E word. Okay, Tony?
Yeah, so going back to the emerging market question, I have a question about the possibility, this is a question to the panel, outside the United States of a emerging market, again, using the phrase that I guess Tim was talking about, it be horizontal, not vertical, across various markets, whether Europe or other legal systems, based on something like what we saw in Germany with the Hausfeld firm funding My Claim, where you have a mass claim, the VW claim, a mass claim which is easily reproducible, and which a capital provider can deploy over thousands or tens of thousands of identical claims. And really what the capital provider is doing is they're stepping in the shoes of what an American class action attorney would do. They're basically using their capital to vacuum up the claims, either purchasing all of them or buying a portion of them, and then using that efficiency of scale to make money off of it. So is that something one sees outside the United States in terms of an emerging market?
No, I certainly think that's right, and that claim is very also being very strongly used and that model in the UK. So there's actually an American firm has come recently to the UK and set up in Liverpool, who are very proactive and are using their marketing skills, which they have used here, very efficiently in the UK. And I think they've picked up something like 80,000 claimants from what we have is called call centres. So we have CMCs in the UK. I'm not sure whether you have them here, but they basically are claims harvesters, and they work up a book of 10, 15, 20,000 claims for a class action like that Hausfeld one that went down in Germany. And they work then with law firms too. There's very few law firms who can do 5,000 claims or more in the UK. So we go into a UK like Volkswagen, we say we can get you 6,000, 7,000 claims. Sometimes they can't handle it. A lot of those firms can't do it. But I think it is an emerging market, and I think it's very interesting as well, because the CMCs in the UK, a lot of people would frown on them a little bit, But there is some they're now being regulated by the FCA, they were MOJ regulated previously, but there's huge advantages to having them because they can book build very, very efficiently and cost effectively, and they are good at it. And my opinion is we're funders. We fund cases, we're not harvesters, we're not litigators. So we stick to what we know well and continually to do it. I think on the previous question as well on marketing, I think we as an industry must now support the creativity around. I've never seen an ad for litigation funding on CNN, ever. We know we're behind, we're still behind because we're a little bit behind the curve of maybe we should come out or maybe we shouldn't. I think that the access to justice point and what I've learned in the consumer lending, particularly in the personal injury space, is how we help claimants against the big defendants who are offering 1.6 million to some guy who's a paraplegic, who can't defend himself, can't pay his rent, has no money, and has an offer that he knows is 9-10 million. And that money, no matter what we make on it, that is a special place for us as funders. Yes, we're not Samaritans and we're trying to make a living, but this industry, I don't think we're as strong in pushing and pressing what a brilliant product it is for everybody, including law firms. So sorry for my continued rant, but I think that definitely in the UK, that's a model that has been, and we're using very effectively as well on various claims. So you've data breach claims is a new area, and has come very much into the UK. So you have a lot of claims against big defendants, huge pools of claimants. And recently one of the claims was settled and it's gone to appeal. And I went to meet the law firm that had 5,000 claims, and we quickly got another 5,000 claims. There's a 100,000 pool. And so we can all jump on each other's bandwagon. I can run 5,000 claims and 4 other funders can have another 5,000 claims. So if we get something that's working, I think we should be working together more often as well. Co-funding is difficult, but in emerging markets, sometimes it makes sense. You see the banks going in, Goldman Sachs and all the big banks go in alongside each other on huge investments, and they have a waterfall system and it works. And I think that could be another part of the emerging markets, because sometimes you deploy 20 million into a claim. I know as a firm, with our portfolio, we can't afford to lose 20 million in one go. And I don't think anyone can afford to lose 20 million in one go. So it's something I think in the emerging markets, maybe that's another thing that we could be looking at in time.
Very different system involved there, where you must opt into the group action instead of in the United States where you opt out. And so you do have these claims aggregators who have to get on the phone and find people with claims to bring them into the class. What's the situation in South America? It's an opt-in system as well, making it harder to build a class, I think.
Yeah, mostly it's related to shareholder disputes rather than consumer disputes. Mm-hmm. That's where the biggest claim amounts are, typical disputes regarding decisions of the boards, disputes between shareholders, disputes among the results of our M&A transaction, but mostly it's shareholder disputes rather than consumer.
Okay, so consumers, if you had a position in a stock where there was a claim, would probably not bring it? It's only the big institutional investors?
Well, actually it's mostly a system that is a state system. There is local institutions, government institutions that look after consumers. There is not like a private system to get, some compensation. It's rather a state system that put punishments. The only system that you could both choose, like a private system or a state system to get compensation, is securities litigation.
Mm-hmm.